moving forward with you with the second question. This one states that, can the tenant bill the landlord for damages for not electricity? So the landlord is not paying electricity. I have a client who stayed for a week without electricity, and the landlord is doing nothing about it. So in this case, the landlord has failed to provide electricity to the tenant, and they've suffered now damages. Is there a breach perhaps by the tenant, Bruno, by the landlord, sorry, by failure to provide electricity for the tenant? And what's the next step for the tenant then?
So it's actually a brilliant question, especially because of load shedding and the fact that we've accepted it to be permanent enough that people have started to negotiate, to market around the fact that load shedding is real. So you'll actually find, interestingly, that this answer is dynamic, that over time it might actually change, unless the lease agreements are very specific about like what happens when a person doesn't have electricity. However, this isn't a question over load shedding. So over here, we're dealing with the intentional or the neglect of a landlord to pay electricity versus something that one could refer to, not natural, but something out of the landlord's control. So if we're looking at something within the landlord's control, it's very different. So the landlord has a lease agreement. In terms of the lease agreement, especially with residential properties, there is an expectation that electricity accompany occupation. It's simple as that. You provide a house and there's only the provision of electricity. Whether the lease agreement says it or not, it's become a norm. It's a standard of a residence. Because of this, the simple answer is the failure to provide electricity by the landlord to the tenant comprises a breach of the agreement, the lease agreement. Now, if you start digging in a little bit deeper, you might want to start asking questions around, but were certain things paid? Did the tenant pay what they were supposed to pay to contribute towards electricity? Did the landlord intentionally switch it off? Did he do it himself? Did the municipality do it? And did the municipality do it because of failure to pay, which the landlord expected the tenant to cover? So just bear in mind, the answer would also vary depending on whether the tenant's in breach of the agreement, because a lot of the time the landlords specifically allocate the payments of utilities towards utilities. So if the tenant fails to pay, the landlord fails to pay, the municipality switches off, right? But let's hypothetically, in this example, because it didn't sound like the tenant was at fault, if the tenant paid everything they were supposed to pay, the landlord somehow fell into arrears and failed to pay the municipality. The municipality did lawfully disconnect the power because it's in arrears. So you can't go after the municipality and you can't insist that the municipality switch it back on. Can a person claim damages? Absolutely. It's the damages that one would claim due to a breach of a lease agreement. So obviously the first damages that come to mind are the normal ones, food going off and that sort of thing. Just bear in mind that a tenant, or anyone for that matter, does have a responsibility to mitigate. So what this means in our law is that, yes, you're entitled to sue for damages, but you can't allow things to happen. You can't allow damages to get worse and worse and do nothing about it because you feel that later you can go after the person, the perpetrator. So, for example, if the power's off and you're leaving things in the fridge for a hell of a long time and you're not doing anything about it, then you might carry some level of responsibility that you should have probably acted sooner rather than later. Another example or things to consider is a tenant entitled? Is the supply of electricity material enough that a tenant is entitled to go find alternative accommodation for the short-term period? That's also an interesting question because it's based on a case-by-case basis. One could say that for one evening without electricity, it would probably be unfair or unreasonable for a tenant to go stay somewhere else. But if you're looking at multiple consecutive days, I would easily argue that the tenant is entitled because he's not getting use of enjoyment over the property and the electricity component being a material component of the lease. So to answer the question, in short, damages, absolutely. The extent of damages would depend, but you'd probably be able to get everything that you suffered because of this. But there are underlying questions that one might need to answer before you get a definite yes or no.
Yeah, absolutely. Yeah.
Yeah, I think from my side, I just want to add, because there's understanding damages in South African law is something that I think people need to understand more about, because a lot of people, when you see these, legal shows, or if you have a basic knowledge of the American system for damages, it's a very different system to what happens in South Africa. So the most important thing for South African law is, when you want to claim damages, it needs to be a demonstrable and provable damage that you have suffered in the circumstances. So there's no such thing, in foreign jurisdictions, we have damages for, reputational harm, and people claim millions and billions. It's not really a feasible thing in South African law. You need a demonstrable, provable amount. So actually, Bruno, I love the example you gave of, if I've got to go stay at a hotel now, because I can't use the property for a week period or whatever, that's a demonstrable damage that you've suffered in the circumstances where you can say, well, I had to stay at a hotel. This is my bill per night over 7 nights. That's the damage that I've suffered. It's a beautiful example of what might be claimed.
And I mean, it opens that door. And I mean, we've faced this so many times. And again, it comes down to mitigation, because then you get the guys taking advantage and going to stay at a very expensive hotel that in no way is measurable against the accommodation they used to have. And again, it goes back down to that. This isn't one of those, slip and fall in America, and all of a sudden now, because you cried a little too hard, you get millions and millions and millions worth of damages. Here, it would be the hotel bill. And even that is going to be questionable, because did it have to be that hotel? Could it have been something of reasonable standard compared to where you're living? Sure, if you're living at a 15 million rand house and you're used to a specific lifestyle, technically, in my mind, something similar, you'd be able to claim like a hotel bill. But if you're staying, whatever, in a little granny flat, and that evening, all of a sudden you go big and you go Tsogo Sun, and here you go, it's penthouse, that's never going to fly.
Yeah.
Absolutely. So thank you very much, gentlemen, for today's episode and answers. Thank you to both our SN agents for the questions, and we'll be having another two questions next week with the P&A team. And that's it for today. Thank you very much.
Perfect. Thanks, guys. Cheers.